When one divorce attorney contacts the other attorney asking that his client not contact the other client, is this an intimidation tactic? Not usually, but it's often, not always, but often a posturing, passive-aggressive move. Unless the court orders no contact, there is no law or rule that bars the parties, even when represented by counsel, from communicating with each other during the pendency of a lawsuit. There are situations where it makes clear, good sense for one party to a divorce to want no contact with the other party, such as when one party is physically and/or emotionally abusing the other party. No contact may be necessary for the other party's protection. There are situations where the client needs to be protected from himself or herself, i.e. the client, if he or she speaks with the other party, may be tricked into making damaging disclosures, admissions, or agreements that the party need not and should not make with the other side. No contact may be necessary to protect the client in such a situation as well. Sometimes no contact may be warranted, if not absolutely necessary, if and when the party wanting no contact desires no contact because other parties' efforts at making contact are not productive, but simply excessive and/or annoying. Otherwise, when the attorney for a party sends the "Your client is hereby on notice that she is not to have further contact with my client" letter or email, it's usually posturing or an attempt to ensure the attorney has more control over the client and the case. Some attorneys like the "You are not to have contact except through me" policy because it then leads to the attorney being more involved in the case so that the attorney can unduly control the client and/or bill the client more.